everyone. Thank you for coming. This is the second in the series of the Portland Buy Local's IndieBiz EDU. And today we're talking all things human resources and employment law, something that we all need to know about that we probably don't want to think about, don't want to know about, but we need to as small business owners. So here we are to talk about those things. First off, I want to just thank Gorham Savings Bank, who has sponsored all of these series. Thank you very much, Gorham Savings. And thank you to Veril for hosting us today in their lovely conference room. And at that, I will let our speakers introduce themselves, starting with Tani.
Hi, I'm Tani Alvarez. I am a labor and employment attorney at Veril. My practice consists of advising small and large companies on best practices concerning human resources and labor and employment needs generally. My practice is both advising clients on those best practices and then also representing them in litigation should they either not come to us or choose not to take the advice that we provide more generally. So a little bit of both within my practice, but all manager, employer-based labor and employment law.
I am Eric Peters. I work at a firm here in Portland named Kelly Remlin Zimmerman, and in some ways my practice is pretty similar to Tani's. I represent companies pretty much of all sizes in advising and counseling and basically trying to keep them out of trouble. Sometimes, as Tani indicated, they listen and sometimes they don't, and I also represent them in litigation. My practice differs a bit from Tani's in that I also represent individuals who are engaged in litigation or claims against their former employers, so I probably do about 50-50 management side and employee side.
So two good people to ask your questions to. So icebreaker question. This is a group of local businesses. So what's the last locally owned independent business that you spent money at, and why do you love them?
Market Street Eats. They are a perfect place right downtown, kind of on the peninsula, to grab food. It's perfect because they also deliver. Funny story, I gave them the wrong address for delivery last week. I actually didn't realize where I was, and it was going to be sent to South Portland as opposed to Portland, where I was. A couple of phone calls, the food still arrived, exactly what we ordered, at the right location, despite my inability to identify where on the peninsula I was. So wonderful business, super great customer service, and a local business I love to support.
That's a good one. That's one that I frequent a lot. Other than various restaurants and bars, which of course it's Portland, everybody hits, I work on Lower Exchange, and I find myself in Sherman's a lot. In fact, I was just there yesterday. I bought a frame for a picture that I'm sending to my sister-in-law of her and the rest of my family at one of my son's football games last fall. So I feel like I go into that place to get a card or get a book or something. Like, it feels like once a week.
Great. All right, now the hard stuff.
Okay.
So our membership tends to be very small businesses. Think, some of them, a lot of them sole proprietors, a lot of them 2, 4, 6, 10 employees or less. So I'm one of those business owners, and I need help. I don't know what I don't know.
Is this for you, or
I
is this
don't know
for
where
everyone?
to go. Is this? No, you know.
Okay.
Eric, full disclosure, Eric has done some work for the company that I own. But no, I don't know what I don't know, and I don't have a lot of time or money. So where do I go? Where do I start?
So one of the things that I do, and so I had my own practice for a while, and one of the things that I do and have done that's a little bit counterintuitive that I did to kind of grow my practice is to give away a lot of resources. And by that I mean I like to tell people where to start, and then if they have questions, come back to me, and then they can spend a little bit less time and a little bit less money if I'm charging them by the hour answering their questions. So I will say that the Maine Department of Labor in particular and the U.S. Department of Labor have really good, really friendly websites. And I get a lot of questions, I'm sure we'll kind of come back to this. I get a lot of questions about wage and hour issues. And the US Department of Labor, for example, has these great fact sheets that are designed for lay people and that really kind of explain things on a level that you don't have to be a lawyer. And so I think for a lot of people, small businesses who obviously, you don't want to spend a ton of money on lawyers, it's a great resource to at least kind of chip away at the problem. And if you can't eliminate your need to talk to me or to Tawny completely, at least you're more educated and you can ask kind of smarter, better questions, and therefore spend less time and less money on somebody like me or her.
Mm-hmm. I echo everything that Eric said. I know he's going to laugh and say, like, that's surprising, Tawny, because usually you just want to disagree with me.
We used to work together, and we used to do a lot of presentations together. So generally the most dangerous place in Portland is to be between Tawny Alvarez and a camera when she's talking about employment laws. So
no, the good news is I agree.
I'm just glad I had the opportunity to get in. Thank you. If you give me the questions first, that would probably be the most helpful from my perspective.
This is why we put Eric between us, is so that it would be a much more natural.
So I would actually get a chance to answer some of the questions before you run out the clock. Not that that's ever happened before.
Local backstories. Local backstories.
So I agree with everything Eric said. There are definitely a host of free material out here. If you're watching right now, I think this is a great opportunity to take advantage of it. A ton of firms in the market also have free resources, and not just, when I say firms, I don't just mean law firms. Consulting firms who do HR work also do blogs and newsletters and white papers. We have a podcast series called HR Law 101 that you can just download all these podcasts. I co-host a radio show. Like Eric said, get between me and a microphone is really tough. So he just gave me a radio show and said talk here so that Eric can also speak. Every week we offer a host of free advice that is really helpful to people. That's called HR Power Hour. And then finally, industry groups. I think joining industry groups, whether or not it's the Retail Association of Maine, the Manufacturers Association of Maine, something that relates to whatever industry you're in, they have so many resources kind of there. You get to talk to other industry members who are experiencing the same issues that you are. You can talk about labor shortages. Whatever you're dealing with, I promise you other people in the industry are dealing with, and using them as resources is really helpful to figure out what you don't know.
Yeah. And actually, I'll throw in one. I'll echo everything that Tawny said, and I remember looking at the HR 101 stuff that you all did, and it's excellent, especially for this audience. One other, going back to the governmental entities that I mentioned, the Maine Human Rights Commission, which I think is mhrc.maine.gov, and the Equal Employment Opportunity Commission also have really good resources for people that are on you don't have to be a lawyer and you're not bogged down in jargon for you to look at to be like, okay, somebody's coming to me and saying that, I'm disabled and I need a reasonable accommodation. Do I have to call a lawyer to deal with this? What should I do? What am I facing here? So again, it's the kind of that first level where it allows you to kind of analyze, okay, this is what I'm facing. Maybe I need to talk to a lawyer. Maybe I can handle this on my own. That I find really helpful.
So what I'm hearing you say as well is that, say I go and I look and I have developed my questions, that I don't necessarily need to hire a consultant for some kind of period of time, that I can hire you to answer my questions for an hour. I can buy an hour of your time. Is that something that is routine?
It is for me, and I think for Tawny. I mean, as I said, I'm about 50-50 with representing individuals and businesses, and Tawny I think is probably 100% or close to it. It's not cost effective to hire a lawyer to be your HR person. Right. I mean, I've done HR type work for various businesses. I mean, I'm not, stuffing the folders for annual enrollment and things like that. But it's just not a good idea to have somebody on an hourly rate to be doing that service. I can't speak, there are a lot of HR consulting companies, particularly in southern Maine. My experience with them, and you may have a different one, is a kind of hit or miss, like almost with any other type of consulting group. If you get a great consultant, super, you're off to the races and it's fine. I've had experiences in litigation where some of these consultants have not handled things, frankly, the way that they should, and it's put their clients in jeopardy. So yeah, and I think from what I hear anecdotally, it's pretty expensive to hire an HR consultant. So yeah, I always think it's a good idea to try to educate yourself on your own. And as I tell people, when you're paying me by the hour, the more you can kind of whittle things down and get to the heart of the matter, the less you're going to pay me, and the better you're going to feel about the advice I've given you and where we're going here. So I highly recommend taking advantage of some of the resources that we just discussed.
And Eric and I both have clients that we maybe hear from once every 18 months. That it's 1 hour, it's half an hour, it's 3 hours, kind of 1 month, and then we don't hear from them for 18 months. And I'm sure the administrators in our firm were like, can we close this matter? And we're both like, nope, because we don't know. That's what we're here for. We're here as a resource to say, like, whenever you need us, we will be available. Call, email. It might be a one-off question. It might even be just a gut check. This is what's happening. This is how I handled it. Did I do it right? And sometimes we're just going to say, yep, next time make sure that you document this or something like that. 0.2 of our time to save, I think, sleepless nights for a lot of clients.
Yeah, and that's just to build off of that. That I think is really, we had somebody come in who's it was a company that does tours in Casco Bay. And their lawyer, who they had for literally the entire 30 years of the business, was retiring. And so we did kind of a dog and pony show at my firm. We had some people in corporate, and we had me doing employment law stuff, and we have a maritime lawyer. And at the end of the day, one of the things that I said to them was, what you're looking to do is pay somebody for peace of mind. Pay somebody so you don't have to do it, but also pay somebody so you know it's going to be done right. I mean, I can do some electrical work around my house, but
but
for my peace of mind and for the peace of mind of my wife and my family, a lot of times we'll go to the bullpen and get somebody who's licensed and knows what they're doing. It's really not that different. I mean, I have clients all the time who are like, forgive my ignorance, blah blah blah. I'm like, hey, you don't need to apologize for not knowing anything about this. I have clients, as I said, who are individuals. I have one client whose case Tanya and I were just talking about before we got on, who's a trucker who would constantly, I'm sorry, I don't know, about reasonable accommodation under the ADA. And finally I was like, Adam, why would you? I mean, if you put me behind the wheel of an 18-wheeler, I wouldn't know, what I was doing. Why would you know my area of expertise? So it's really that. It's really kind of when you hire any type of a consultant or put somebody in a consulting role, which is kind of what we do. You're paying for their expertise, and one of the things you get, hopefully, is that peace of mind that Tawny mentioned.
So let's jump right in then to some of the types of questions that I think our members might have. And first is, okay, so now I'm hiring someone or I'm hiring another someone. What are the types of employment, right? There's different, and how should I be classifying people, and how do I think about whether they should be employed part-time, full-time, contractor, et cetera? How do you navigate that?
So I'll take the first cut at that, and then you can tell me everything that I said that was wrong or that I didn't say. So part-time, full-time, excuse me, that's a lot dependent on business needs, and if you're a startup or you're a new business, a lot of times you're not going to be offering benefits. And the reason that I bring that up is a lot of times with your various types of insurance, how much somebody is working will determine whether they are entitled to health insurance, short-term disability, all the other, all the benefits that you offer. Other than that, it's not really, part-time versus full-time. It's kind of a distinction without a difference in a lot of ways. The biggest issue, and I think that, or that I'm seeing with my stuff is employee versus independent contractor. And if you're an employer, you want everybody to be an independent contractor because you don't have to take taxes out, you don't have to pay FICA. It's easier for you, it's cheaper for you, and frankly, it's better for the individual in a lot of situations because they control their own destiny. When you're a 1099 employee, you can pay yourself, at almost any rate you want, and you can do a lot of things with your retirement and taxes that you don't have the freedom to do when you're an employee. the kicker is you can't just wave your magic wand and say you're an independent contractor, not an employee. There's various tests that have to be met, and if you don't meet those tests, then you're going to get in trouble with, among other things, Maine IRS, federal IRS, and potentially the Maine Workers' Compensation Board. So that to me is a big one that I see is misclassifying employees as independent contractors, and just thinking, I had somebody the other day who came to me and wanted me to draft an independent contractor agreement for them, which I did. And then she said something to the effect of, "This is great. Now I'm just going to essentially fire all my employees and make them independent contractors." Like, hold on. No, we're not going to do that. And going back to what I was saying about resources that are available, you go to the Maine Department of Labor's website. They've got like a 12-factor algorithm that says, is your employee doing X? If yes, keep going to the next factor. If no, they're an employee, not an independent contractor. So that's a huge one. And the other one that I see that's big in terms of mistakes that small businesses make is categorizing employees as exempt versus non-exempt. Yep. So we've all had jobs where people are salaried, and then there are people that are getting paid by the hour. And people just kind of, or at least in my experience, people tend to assume that if you're being paid by the hour, you're non-exempt, and if you're being paid a salary, you are exempt. And by exempt, I mean, exempt means a lot of things, but among others, it means exempt from minimum wage and exempt from overtime. And it's a lot more, it's way more complicated than that. You have, in order to be exempt, you have to make a certain amount of money. In Maine, it's like $36,000, $37,000.
It's actually, so 56. 52, yeah.
Okay.
Yes.
This is
yeah,
what
no.
I- this is
yeah.
why you're
No, so it's a
looking
much,
for me.
under federal law, Eric's absolutely right,
Yep.
but under Maine law, it's in the 50s. So if you have anyone who you're paying a salary who makes under $50,000 a year, they should be receiving overtime.
Yeah, they're entitled to it when they work, and among other things, that means they have to keep track of their time. But the other piece to that is it's not just how much you make, it's the duties you perform. And in order for you to be exempt, and going back to what I was saying earlier about these Department of Labor fact sheets, they've got great resources that can kind of tell you, hey, if you're an executive, if you're potentially subject to the executive exemption from overtime and minimum wage, this is what you need to be doing. And there's 3 or 4 exemptions that are kind of commonly seen, but there's a lot of them, maybe not a lot, but there's definitely some of them that are not intuitive and that you wouldn't know about unless you hired somebody like Tawny or me. So for example, I had a case, I think I settled it right around this time last year, where a guy was working as an inside salesperson for a company. And this was a company out of Massachusetts that had a branch in Maine, and he's an inside salesperson. He doesn't punch a clock. We're not going to pay him any overtime. And they fired him for reasons having to do with his illness, and he brought a claim in front of the Maine Human Rights Commission, which was not that meritorious, but when in talking to his lawyer, she said essentially, yeah, we know this claim isn't that great, but we've got a wage claim for overtime and that we think is really good. And the law about inside salespeople being exempt is clear as mud. And so we settled the case for not a ton of money, but it wasn't because of the claim that had been brought in front of the Maine Human Rights Commission. It was because of the wage and hour claim. And not to get too far off on this tangent, but wage and hour claims are particularly nasty under Maine and federal law because the person can get 3 times their damages, so 3 times the amount of wages that they were owed, and their lawyer gets their fees. So if you have one of these cases where generally a former employee is saying, hey, you didn't pay me everything I was entitled to, or if their lawyer is saying that, there's not a lot of incentive for the lawyer to settle the case quickly because the meter is running with them.
And oftentimes, I mean, to add on to that, for small businesses, there might just be one person in that position, but in some small businesses, there might be 3 or 4 people in that position. And for larger business, there could be a dozen. That lawyer very quickly is going to say, wait, if you were screwing it up with my client, I bet you screwed it up with the other people with the same job classification. Yeah. And then they have a class action lawsuit. So take whatever, Eric settled that matter for, times it by however many people are involved, and it very quickly is a 6-figure case, and it's something that you unfortunately can't insure against.
Right.
A lot of the stuff Eric and I are going to talk about today, you're going to want to talk to an insurance agent about. Talk to your broker. Am I insured against a claim of discrimination or harassment? Do I have, it's called EPLI insurance. Wage and hour claims, misclassification is what they're generally called, that you've inappropriately classified someone as an independent contractor or exempt or non-exempt. In most cases, you can't insure against that. You don't have a policy that's going to pay out if you ever get sued.
Yeah, so just to piggyback or build off of what Tani just said, this EPLI insurance or employment practices liability insurance, probably if you're a 1 or 2 employee shop, then you probably don't need it, and it's probably cost prohibitive. But once you get to the 5 or 10 person level, it's worth certainly reaching out to your insurance agent. And one of the things that I will say as a lawyer who predominantly did insurance defense type work for the first 15, 20 years of my career and now does more plaintiff side work is insurance is a huge factor in litigation and in driving settlements. So one of the most important things that you can do when you're starting your business up is find an agent that you like and can work with and who knows your business. Get recommendations from people who, hey, is so-and-so over at XYZ good? You might want to stay away from them. Get good word of mouth, because a good insurance agent can really help you. Because it's like the old expression: by the time you need a friend, it's too late to make one. By the time you're hoping there's coverage for this frivolous discrimination claim, what there's not, you're still going to have to pay me and Tani. I was going to say some sum of money. Her rates are a lot higher than mine, but more than you want to. More than you want to. So that's a great, from a lawyer, that's advice to get insurance and get somebody on your team who knows insurance. And it really does make a difference. I mean, I used to think, an insurance agent is an insurance agent, but it's like with a lawyer or a doctor or anything. There's good ones and there's bad ones.
If someone wrote your policy and you didn't have an opportunity to sit down and talk about your business, what you do, how many people you have on your team, how many clients you have, your breadth, like are you only servicing Maine? Are you servicing Greater New England? Are you only servicing Portland? Kind of those questions to get a sense as to your operations. You may want to consider having someone else look over it and give you a second opinion as to what they would have written for policy coverage for you.
And it's also a good idea to, it's kind of like nobody wants to go to the dentist, but once a year you get your teeth cleaned. Once a year you meet with your insurance agent just to say, okay, is everything still the same in the business? Are we still insuring for the same risks, or are there additional risks that we need to look at? And are there things that have changed that we no longer need to cover? And that can end up saving you some money.
All right. So let's move to, we have our employees, but now unfortunately we have to let somebody go. I think that's a big question. So before that, I guess, becomes performance reviews. So maybe go through what should I be doing so that when I get to that point where I need to let someone go, what are all the steps that I need to be taking as far as performance reviews, warnings, disciplinary action, and then finally termination?
For smaller entities, I believe in real-time feedback. In large part because if you are a smaller entity, if there is 1 or 2 people in your shop, you're wearing a lot of hats, you're juggling a lot of balls, and to be able to be like, okay, every May 1st I'm going to do performance reviews for this person. I love to think that that's realistic, but at this point in time in my practice, it's just not. I rarely see an organization that can effectively kind of schedule that in advance, set aside the time, and be able to do it. In real time feedback followed up with an email that says, hey, you and I just had a conversation about this. This is my expectation moving forward. Let me know if this is unclear or you have questions. It sounds redundant, and you're going to say, Tani, you just said I likely don't have time. Now you're telling me I not only have to have a conversation, but then I have to follow up with an email. Anyone who's worked with an attorney knows that we want something in writing. If it's not in writing, it's much harder for us to prove that it happened. And so often people are like, wait a second, I thought I'm not supposed to put anything in writing because it could be used against me later. In this situation, we want a chain of documents that say, hey, we performance managed this person. We had issues with them. We gave you notice that you weren't meeting our expectations. Because the last thing Eric or I ever want is to get a phone call and we're both going to ask the same question. Is this going to be a surprise to the employee? Right? And if it's a performance-based termination, it should never be a surprise. If we're terminating because of economy issues, right? Hopefully the employee has a sense like, oh, I knew things were slow, or we haven't had people in, or I knew business was down. So at no time should it really be like, ooh, I didn't see that coming. If it's a performance management issue, you need to have the documentation and try to work with the individual to make it work. If it's an economy issue, there probably should be discussions beforehand about like, hey, business is really down, thoughts on other things we could be doing, kind of bringing them into the loop as to where you are from a business sense.
Yeah, I definitely echo that. I mean, just to kind of bring it back to a little bit more in terms of the basics. In Maine, unless you have an employment contract specifying, hey, I can only be let go for cause or for these reasons or that reasons, you're an employee at will. And that means that means a lot of things, but in this context, it means you can be fired for any reason, good or bad, as long as it's not an illegal reason. And illegal reasons are typically your race, your gender, your religion, your disability status, your age. And I tell people the stupid story I always tell people to illustrate it is I used to, when I was working at other law firms, I used to have to wear a coat and tie. So one day I come in and I'm wearing my coat and tie. My old boss comes into my office and says, Eric, that's the ugliest tie I've ever seen. The fact that you would wear a tie like that shows you have no judgment. We can't have lawyers here who have no judgment. You're fired. Now, would that be a good reason to fire me? No. Would it be an illegal reason to fire me? Also no. And I get, because my practice involves representing individuals, I get a lot of phone calls that are basically, that can basically be summed up as, I was fired. They said it was because I was doing a bad job. I wasn't doing a bad job. Is there somebody I can sue over this? And I tell that story, and then I refer them to like 3 or 4 other lawyers who might be more interested in their case. But that's really it. I mean, you don't have to have a quote unquote reason to fire someone as long as your reason is not an illegal one. However, in order to ward off potential discrimination claims, it is great to do exactly what Tani said in terms of documentation and to do it in real time. I am not a fan of the annual performance review. I've sat through too many of them that were just, it's basically you haven't been doing your job all year, but we know I'm not going to fire you, and so let's just pretend like you have been doing your job all year and hope things get better. And at least in my experience, they never did. So in terms of documentation, and I have clients whose response is essentially, well, I don't have time to do all of that stuff. You do, actually. You have a cell phone. The cell phone has a record feature. You can dictate into it. 125 talked with Tani about problems with, her response to the client who asked for da-da-da-da-da-da-da. Told her that this needs to improve immediately. It's costing us money, period. Send the email. I have a Tani Alvarez quote unquote personnel file or stuff that I keep emails about Tani's performance in Outlook. Drag and drop. Then if there's a problem and I have to let Tani go and Tani lets me, says, hey, you fired me. In Tani's case, it would be because she's too young, not because she's too old, as opposed to me. Then you've got something that you can show the plaintiff's lawyer that says, au contraire, I fired her because we had 98 performance issues that I've documented thoroughly here. So that to me is a big one. And not to get kind of too far away from what you were talking about, But essentially, almost every discrimination claim that goes to litigation is some variation on, I was fired because of X protected characteristic. No, you weren't. You were fired because of Y performance issue. And then the issue becomes whether that performance issue is pretext for discrimination. So if you have this real-time documentation, like Tawny mentioned, as opposed to, oh crap, I got notice that Tawny's going to file a Maine Human Rights Commission claim on Tuesday. On Wednesday, I'm going to document all the problems that she had. I mean, that looks shady, obviously. But if you're doing this in real time, and it really does not have to be much more than literally talking into your phone, which we all do pretty much every day, then you've got that resource, and whether it's Tawny or I defending you, we're going to be a lot happier about your situation.
Shady is one of those really serious legal words. But Eric, what happens if I wanted to take out the middleman, and could I just record the conversation with the employee when I'm giving them that real-time feedback? I mean, we've got our cell phone. Could I just put the cell phone down, start recording, have the conversation? Would you recommend that kind of generally?
So about 20, I'm going to tell a war story. So about 20 years ago, I was involved in this super contentious case involving the ownership of a car dealership. These two guys who had been partners, and then they had a falling out, and then they decided that they hated each other's guts. And the lawyer that I was working for, and the lawyer who was involved, hated each other as well. So it was really just a period in my life. I look back on and literally reach for a bottle of tequila. And anyway, in the discovery process of the litigation, somebody revealed, we've got this relevant document, that relevant document, and we've also got a recording of Eric Peters talking on the phone to witness so-and-so. And I was like, excuse me? So I had been recorded without my consent, and Maine, this is for all of you who have operations only in Maine. Maine is a one-party consent state. So yes, you can record your conversations. I don't like it. I mean, maybe it's a generational thing. I think, to use that legal term, shady, again, I don't think it looks right, but I see it. I wouldn't say I see it all the time in my cases.
And one consent, meaning I don't need to consent.
Meaning, if you and I are talking,
right.
and I'm recording it, I have consented.
You consent, but I don't have to consent, just to clarify that.
Yeah,
okay.
Thank you.
Yep.
And I don't have to tell you that I'm recording it either. I don't like it. I think it looks bad, but I definitely see the evidentiary value of it, and I don't know about you, I see it a ton in my cases now where people are recording things. Mm-hmm. I will tell you.
Video as well?
Less video, more audio, because video, you have to.
Right.
Yeah, you have to be more involved. But I will tell you, and this came up. Excuse me. This came up in a case recently where a client of mine. It was an ADA discrimination case, Americans with Disabilities Act case, and he was in Maine, and he called someone in New Hampshire and recorded them. New Hampshire is a two-party consent state, and I got to learn all about how the law works there. And generally speaking, I'm sure there's some disclaimer that you're slapping on this thing, that this is not legal advice. If not, this is not legal advice. But the state you are in, the state where the recording occurs, that law governs. So he was in Maine, a one-party consent state. The fact that New Hampshire was a two-party consent state was irrelevant. But there was definitely some anxious moments on our side when the other side raised the issue of this is illegal and we're going to prosecute you under this. New Hampshire has a statute that says you can be prosecuted for intercepting wireless or wired communications if you don't get both parties' consent. So anyway, I'm not a fan, but it does have evidentiary value. If you record something in real time, like if I, talked with, just got done talking into my phone, just got done meeting with Amy, told her X, Y, and Z about her performance needs to improve, send. I mean, yes, they can say, well, that didn't really happen, did it? Mm-hmm. But I don't know. It doesn't sit. To use another legal term like shady, it doesn't sit right with me.
I agree with Eric. I mean, there's things that are legal to do firing someone because you don't like their tie, but it doesn't mean it's best practices. Similarly, I have a lot of cases where there is an individual recording on their cell phone. There's a lot of why did you feel the need to do that? Why did you make that choice? Did you know that you were doing something wrong and that's why you wanted to record it? A lot of those questions pop up. So I do think Eric's advice of like memo to self directly after is the best practice as it relates to dealing with performance concerns or dialogues more generally.
So we have a lot of people online, so I wanted to ask if there's any questions that have come into the chat online.
There are a couple.
Okay. Let's hear.
Let's see. So Christine wants to know, says, most of the LLC small Portland businesses I know have liability insurance. Can you clarify again if this is fine for a small business with 1 to 3 employees? And also, do you recommend that independent contractors sign a contract?
In terms of 1 to 3 employees, I don't think you need the EPLI coverage that we were talking about. I think it's always a good idea to find out how much it costs. I mean, some industries it's prohibitive. I have a friend / client who's been in the restaurant industry for a million years. And restaurants, bars, just because of the types of people that generally work there and the fact that there's alcohol and a lot of times other drugs that are involved in the workplace, are notorious for employment-related claims. So he has about 20 to 30 employees, and he's worked in the restaurant industry his whole career. He started his own place about 5 years ago, and I bugged him for years to get EPLI insurance as soon as he could. Literally, and he's in Texas, and he actually got it through an insurance agent I know up in Maine, who's a really good insurance agent. And literally within 6 months of his getting the coverage, he had a claim. And once you get a claim, the coverage pretty much pays for itself. It works like any other insurance where you pay your deductible or self-insured retention, and then after that, you don't see bills from me or from Tawny. So 1 to 3, I think you're okay, but it's a good, if your goal is not to become anything more than 1 to 3, then you'll probably never need it, as long as you have what I will say is a no jerks policy, which means don't hire people that are jerks. But
another illegal.
I decided to go with my PG material on that one.
Appreciated.
But if you're looking to grow, like most businesses are, then it's at least worth talking to your agent about it. And then in terms of
independent contractor.
Me for independent contractor, because I don't have anything to add to the insurance question. For the independent contractor, you absolutely should go to the Maine Department of Labor website that Eric mentioned earlier. One thing, always make sure that at the end it says .gov, because Google does a great job of pushing forward non-government websites. But go to the maine.dol.gov, type in independent contractor standard. You're going to see one of the elements there is that there is a written contract and that there are in place ramifications if somebody breaches the contract, if you end the contract, and maybe it's not a breach, it's just, hey, contract's terminated, but the project isn't done. What are the ramifications if something like that happens? Also, payment terms becomes one of the elements of whether or not somebody is appropriately classified as an independent contractor or an employee, and that goes to like ability to experience a profit or loss. If you're paying someone on an hourly basis, it's less likely the person can experience a loss versus if you're paying them on a project basis. I will pay you $3,000 to do this marketing campaign, right? As opposed to I'll pay you $18 an hour to do this marketing campaign. Okay, you hire Eric and I to do a marketing campaign at $18 an hour. It's going to cost you $10,000 because neither of us know what the heck we're doing, right? Versus, $3,000 to do this marketing campaign Eric and I are probably working at 2 cents an hour at that point trying to figure out how to do marketing. Those are elements that are set forth on the DOL site, but having a contract in place is definitely a helpful element so that you can show it was a true independent contractor arrangement and that the individual shouldn't have been classified as an employee.
The other thing you can do, and I'd be curious about whether you recommend this or not, I generally do not, because I think it's kind of like poking the bear, is you can actually go to the Maine Department of Labor, and there's a form you can fill out to apply for predetermination of independent contractor status. I actually had a case where someone attached that form to an independent contractor agreement. Didn't look like, I don't think they did. They didn't actually get the predetermination, but that is an option. I have never recommended to my management clients that they do that, just because, like I said, I feel like that's kind of making yourself a target.
The only time I've ever done it, so that's a great question. The only time I've ever asked for a predetermination letter is when my advice has been this individual cannot be an independent contractor, and the individual is saying, I will not be an employee. You have to use me as an independent contractor. And I feel as though it's high risk, because just because the individual is saying, I want to be an independent contractor, they could still sue you later and say, I should have been an employee, I was injured, I don't have workers' comp. So normally in those situations, I say, okay, get me proof of insurance from the independent contractor that they're insured, that they have their own workers' comp, that they have general liability insurance, and also get me the predetermination letter. And if the independent contractor themselves gets it, then I'll say, yeah, you go ahead and give it to us. But normally I, as a management side attorney, am not saying like, we'll go to the Department of Labor and put us on their radar to do a wage and hour audit.
Right.
Okay, we've got several questions here, so I'm going to give you another one. Is there any mandatory COVID vaccine law in Maine that allows you to mandate the vaccine for employment?
Healthcare workers. So one of the firm that I work at, it's a lot of attorneys who have kind of, it's somewhat similar. Tani works at a much bigger firm than me, but the setup is somewhat similar in that we have a lot of people who are in other specialties, and I have a colleague who does a lot of hospital work. And I have done the ins and outs of mandatory COVID vaccine. It's funny because all the COVID stuff obviously blew up in 2020, 2021, and now, at least for me, it's largely gone away. I mean, I'm doing some cleanup stuff. And I actually, about 2 weeks or so ago, was looking at the main regulations that govern vaccination, including COVID vaccination, but not for COVID vaccination. It was because a hospital that we represent wanted to, had a provider, a locum tenens provider, and he wouldn't get his flu vaccine. And the flu vaccine, along with hepatitis vaccine and a couple other things, are mandatory. But yeah, on the state level, and I haven't been following it on the federal level, maybe you have, it is still mandatory that you be vaccinated if you're a healthcare worker. I don't believe that they have gone any further than, in terms of requiring boosters.
My understanding is that there isn't that booster requirement, that it would be the 2 rounds,
or the one if you're
or the
Johnson
one
Johnson.
if J&J. From a federal level, there's still a requirement on the books for individuals who are government contractors. However, institution of that rule is still stayed.
Right.
There was a mandate for employers with 100 plus that no longer is applicable. OSHA is supposed to release new guidance at some point this year about what their recommendations are, but we still don't have generally applicable OSHA guidance as to COVID vaccines. And then other than for healthcare providers, but the healthcare providers also does have a medical accommodation that's built into it. There is, however, no religious accommodation. So you cannot ask for an accommodation based off of religious beliefs, but there is legislation before Augusta right now to get rid of that.
There's a commentary in the stuff that says, in the main mandate, that says, hey, it's just, and it's been litigated about whether it's constitutional to have a requirement that people can be exempt because of a disability or something physical, but not religious. So there's actually something in the main rules that says, well, even though we say that there's no religious exemption, you have to apply this rule consistent with your obligations under state and federal law, which require you to have a religious exemption. And so I've had the COVID litigation that I've been involved in has involved healthcare workers who've sought religious exemptions. And I represented a guy for a little bit who was challenging one of the mandates, and we ultimately settled his case. And this is a whole nother issue, but one of the ways that the company defended it was, and I couldn't believe they did this because he was a pretty devout Christian, was, your religious belief isn't sincere. Which is like, okay, really? You're calling me a liar when and there has, without turning this into, Meet the Press or whatever, there has been a lot of stuff about people getting bogus religious exemptions and stuff like that. This guy was a pretty devout Christian, and there's another way to defend against those cases, which is essentially, hey, your religious beliefs, let's assume your religious beliefs are sincere. It would be a hardship for us to accommodate them because of X, Y, and Z, which is the way more conservative way to defend it, and I think the way more effective way to do it.
So outside of healthcare workers, which a lot of our members probably aren't, that's not something that they can legally do.
They can do
it as policy,
yeah,
correct?
they can mandate it. It's not mandatory from the
They can do it as their
state.
own policy.
Yeah.
Yeah.
And I don't know if you're still seeing much of that. I'm not.
Not a ton of it. Honestly, not a ton of it. We get one-off questions about people who are refusing to come to work still if they were previously working remote, but it's not a big part of the practice right now.
Yeah.
Do we have additional questions?
One more. What information can you look up before hiring someone, i.e. public information through Google registries, etc.? I think that's like, can you stalk them on Facebook before you make an offer?
Do you want to go?
I'll let you
Okay.
go.
So two things. One, there's a difference between a background check that's conducted by a third party, which would be a credit report, would be arrest records, would be like a very thorough review. If you're going to do something like that, you have to follow both Maine and federal law, which requires that you get a release from the employee that provides their name, contact information, so that you know that you're getting correct information about the individual. Depending on different industries, childcare, healthcare, direct support providers, those type of industries, oftentimes there's legal requirements that you do some form of a background check to make sure that they don't have arrest records, or that they haven't previously been cited, or they have appropriate licenses. More general though, let's say somebody applies and before you decide to bring them in, you do a Google search and front kind of page Google says this person was arrested for an OUI last week, or this person has domestic assault charges pending against them. Remember that you cannot take into account charges against a person, right? Like just because someone's been charged with a crime, I could walk out of this room and be charged with any crime. Is it likely to happen? I hope not. I mean, I don't think so. You guys can all choose whether or not you think that's likely. But a charge is different than a conviction. Okay, a conviction really is the only thing that matters. Let's say though you're doing a social media check to see whether or not I post racist or misogynistic kind of posts more generally from a PR perspective. Will this person be a good fit with our culture? Are they forward-facing for our organization? You can do that. I like to say it should be somebody who is uninvolved in the hiring process, who does a scan and says, I didn't find anything concerning, or I did find something concerning, you might want to take a look at it. The reason I say that it should be someone outside of the hiring decision is because there's a chance that you're going to find information that's protected that could create a legal issue. So let's see, you do the Facebook scan, you find out that I have a child who has a disability, and you think to yourself, ooh, How's she, like, she's a single mom, she's got a child with a disability. Is she going to make it into work on time? Like, think about all the things that could come from someone's mind when they hear just those factors. That could be an illegal reason for you not hiring me. So I could make a claim that it was failure to hire in violation of the Maine Human Rights Act based off of my family status, and could potentially have a claim. So there are some risks to it. I like saying someone outside of the hiring decision should take a look, say nothing concerning, or there are some concerning things, take a look. I also like it to be after we've made a hire decision. Yes, this is someone we want to bring on board. Last step, let's check it out. Eric?
Yeah, I mean, I would echo that. I would also, if you're going to do background checks, you should hire a third party to do them. They can do them better than you can. They can comply with the law. You really have to read the fine print in the agreements you sign with those groups, because a lot of times they'll say, well, if we do anything wrong, we're not liable for it, you're on the hook for it, which kind of defeats the purpose of having them. So that, and the only, I guess the only other thing I would add, two things really. One is you can't force someone to give you their social media passwords or to allow you to friend them on Facebook or let me follow you on Twitter. That there's actually a Maine statute that explicitly prohibits that, so be careful there. The other is, I was actually involved in a case, it wasn't really a case, it was just a client coming to us for a consult, where a guy had said, they'd gone through the hiring process and it was to the point where they were about to hire him, and they said, anything else we should know about? And the guy said, well, I was involved in this fairly high profile criminal case in the 80s, and it turned out he was part of a spying scandal that involved the US, and it was so long ago that there was a USSR. And they were they were floored. He's a super nice guy. He's just like they were hiring for like a maintenance or a custodial position. He had done a bunch of years in federal prison as a result of it. And they came to us and they were like, we don't have a problem really hiring him, but what do we do? And so we talked to him about it, and there essentially was nothing saying you can't consider that. I think they ultimately did hire him, but it's always best, I find in these situations, Tawny mentioned earlier about terminations not being a surprise. I think it's always best to have kind of a dialogue with the applicant before you make the decision, and involving your lawyer as well. But so it's not nope, we're not hiring you because you sold secrets to the Russians in 1982. It's, hey, we're seeing this. Does this involve you? And there is actually, there are limitations on what you can ask people about their criminal activity under Maine law as well. And I guess the only other thing I'll mention is in terms of social media stuff, that law changes constantly. And one of the reasons it changes is there's an organization called the National Labor Relations Board that when there's a Republican in the White House, they get to appoint 3 out of the 5 members. Well, the president gets to appoint 3 out of the 5 members. So the politics of it change every time an administration changes. So you'll get conservative, under Trump, it was much more conservative. Under Biden, it's way more liberal now and way more worker friendly. So I do handbooks, and hopefully you have somebody that can do that for you. But whenever I draft a social media policy for one of my management side clients, I always tell them, I always put in a little caveat like, hey, this is current as of now. If you're going to fire somebody based on social media posts or discipline somebody, come talk to me or come talk to somebody else, because 6 months down the road, this may not be what the law is.
So that kind of brings up another question about, the employees having their social media, and now they're employed, and you need to worry about what they're putting out there after the fact. And going back, I remember, this is now going back 12, 13 years ago, being asked by someone who was interviewing me and asked me, do you have a Facebook page? And I said no, because at the time I didn't. They're like, good, well, we looked to see if you did.
You can
Can I even say that?
I can look. I mean,
Yeah.
the reason I was able to find out more about this former spy who was going to be a custodian, that sounds weird to say it, but, was I Googled him. So you can look to see all of this stuff. I just can't say, all right, be my friend on, give me your password, give me all of that stuff. going back to what Tawny was saying about the situation with the person as a child, you see people all the time on Facebook or on social media that are promoting particular causes. I went on a run to kick cancer's butt. That was my thing. And do you have cancer? Is this going to drive my healthcare costs up? So going back to what Tawny was saying, there are a lot of traps for the unwary, and I get it. I mean, people are, social media has been around enough now that people have gotten somewhat savvy about it, so that they don't post everything.
Some people, I don't know. Where you give people so much more credit than I do.
I was gonna say that. I was gonna kind of say that as by saying I can remember, when Facebook was first starting to be a thing, a former colleague of mine, hey, come look at this funny Facebook video I posted when I was absolutely hammered on a boat and fell off, and I'm just like, oh, you actually you know who it is.
Okay.
Yeah, we'll talk more later. But I was just like, why? Okay, great for you. But yeah, it's definitely something where that's, we talked earlier about paying someone for their expertise. That's somewhere where you're going to want to pay somebody because you're not following what the NLRB's decisions are in terms of employee privacy, and not to turn this into a song and dance about the National Labor Relations Act, but it's a law that applies to almost all employers, and it gives employees broad protections about communicating with other employees about issues of joint concern. And so a lot of times, somebody goes on Facebook and posts a video rant about how terrible their employer is. He's not paying any of us overtime. You're fired. Well, you know what? You just violated the National Labor Relations Act because he's not paying any of us. Could be, an issue of joint concern, talking about people's wages. So you really need to be careful about that area for sure.
Do you have any other questions online?
No, I have one. Do we have time?
Let's go over here first.
You mentioned handbooks.
Actually, can you look into the mic just so that people online can, in the recording, know what you asked?
You mentioned handbooks quickly, and what is the best way to get a good employee handbook, or any good places to start with for that?
So I've been, despite my youthful good looks, I've been doing this for a while. And I actually, when I first started to do employment law, that was one of the things that I did, was I cranked out handbooks for people. I remember one year, about 20 years ago, I looked back on my billing and I had done 15 handbooks in a 12-month period, and I wanted to blow my brains out. They're just, they're great from an employer's perspective. Once you get to a certain level, and I'll get to that in a second, you definitely need one. They're pretty basic for lawyers to do. So there are resources where you can kind of start with your own on SHRM and other websites like that. It's cookie cutter.
SHRM being what?
Society for Human Resources Management, which is a pretty good resource if you become a member, in terms of, it doesn't cost a ton, in terms of being able to access, various resources that are, I think generally helpful. Usually what I will do for our existing clients who need a handbook or need a tune-up of their handbook is I'll kind of look at what they have, and sometimes it's, frankly, there's the expression, we had to destroy the village to save it. A lot of times with people's handbooks, it's just easier to throw them out and start from scratch.
Sometimes I do that with the ones that are on typewriters. I've gotten before ones that I've gotten the carbon copy, and they say, this is what we have, can you work from this? I said I could, but it'll cost you 3 times what it would cost for me to throw that away.
It's like a lot of things. Sometimes rewrite. Back when I used to edit your stuff, when we worked together, it was just a lot of times it's just easier to start over. That's a joke. But one thing I will say for really small businesses, I don't think you need, and I don't know if you agree, I don't think you need a full-blown handbook on day one. What you do need, I think, and I'd be curious to hear your opinion, is you need various policies, including your anti-harassment policies, and you need to make sure people are signing off on those. That is one of the things that gives you the most bang for your buck. Because if you're ever involved in a situation where somebody is claiming I was sexually harassed, I was racially harassed, by another employee, you're going to, employee A says I was sexually harassed by employee B, and it goes into litigation, you're going to want to show that you had a policy that you promulgated that to employee B that he or she signed off on, and you've got their signature page that shows that you at least took that step. I mean, you need to do a lot more, obviously, but that's kind of a prerequisite, is having, I like anti-harassment policies, anti-sexual harassment policies, and a whistleblower protection policy. Like if somebody comes to me and says, I don't want to pay, I don't know, $2,000, $2,500, I think is probably about what we would charge for a handbook, maybe a little bit lower, depending on what it all involved. But just having those 2 or 3 policies at a minimum, and the key, along with the policy, which is pretty boilerplate, frankly, is making sure you have a signature page showing receipt. And then once you get a little bit bigger, 15 employees, in Maine, you have to do anti-harassment training. And I don't know if you're still doing those. I do a decent amount of those every year.
And that's annual, right?
Yeah, it's annual, and then you have to do an anti-harassment notice every year. So let's say I employ 20 people, I hire you, I have to give you the training. And you can hire me, you can hire Tawny, you can do it online, there's a million ways to do it. And then after that, you do annual notifications. But you're definitely going to want to have, a lot of employment law is kind of prophylactic, and having the stuff in place for when the inevitable shit happens moments occur, which at least in what we do for a living, that it always does occur. So that's what I like to tell people when they're like, I don't really feel like I need all the bells and whistles. What do I need?
So I want to make sure we're getting all the questions. Do we have any more questions?
We do have another one.
So why don't we're going to get all the questions. We're going a little bit over time, but I want to make sure everybody gets them answered.
Says we're a small team, and everyone wears multiple hats. How important are defined job descriptions?
It helps, job descriptions help set expectations. So if you're later going to tell someone that they're not meeting expectations, it's important that they know what those expectations were to begin with in order to hold them accountable. So there's the accountability aspect is the first thing. The second thing is it's important for some type of written document as it relates to accommodations. So specifically, we see it most often would be requests for accommodations as a result of a disability. So saying, and it could be work-related, it could be non-work-related, but I slipped on the ice, I can't lift more than 20 pounds during the course of the day. Okay, but we're a manufacturing shop and you're supposed to be lifting and carrying stuff all day long. So do you just sit there all day long? Having a document that sets forth, these are the physical and mental requirements of the job is important. It could be that, other expectations are evolving, but having a set expectation based off of what that person does on a daily basis is important. The only reason you wouldn't have a job description is if the job description did not accurately portray what the person was doing. So if you said it is the expectation that you are in the office every day, 8 to 6 o'clock, that you take a half-hour lunch at noon, and then Eric and I walk in, and it's nothing like that, that job description isn't worth what it's written on, and we could care less. So it's important. It's not live or die, but what you're going to run into is either disciplinary issues or accommodation concerns if you don't have it.
I am a huge fan of up-to-date job descriptions and actually working with the employee to help craft those job descriptions for all of the reasons Tawny said, and to just elaborate a little bit on something she mentioned about the Americans with Disabilities Act or the anti-discrimination provisions of the Maine Human Rights Act. An employee is entitled to a reasonable accommodation for their disability that will allow them to perform the essential functions of the job. Therefore, if you do not have the essential functions of the job set out, how can you, how can you say one way or another whether they are essential or not? And I was talking to somebody recently, a guy that I went to law school with who's an employment lawyer in Austin, Texas, and we were talking about our practice. And I was saying that probably the majority of my cases involve disability discrimination. And I just got settled. I just settled 2 cases, one on the employee side, one on the employer side, where the issue was you couldn't do the essential functions of the job with or without a reasonable accommodation. Yes, I could, and these weren't essential functions, and here your job description even tells me that they're not essential. One of them, we were dead to rights because the job description was so poorly drafted. It wasn't that it was poorly drafted, it just hadn't been updated in a million years, so it didn't reflect the current functions of the position. So I'm a big fan of that. I think that's one of those ones where it's a pain in the butt to do it, but I think you get a lot of bang for your buck. And as I said, I think if you involve the employee if you involve the employee, it's helpful on a couple levels. One, it shows that you care about their input. The other thing is if that employee comes back to you and says, sues you for disability discrimination, the issue is whether something's an essential function or not, and you can say, wait a minute, I talked to you. You're the one that told me this was an essential function. That's going to help you in their case.
Anything else from the audience?
Can I ask a
Yeah.
question? So in the case of a caterer, they have some events that take 50 employees and some events that take 5. Is there a cutout for independent contractors in a situation like that where they might have to go grab somebody out of the audience to 10 bar?
You're gonna
On
get
the fly.
it depends. In most cases, because the business is catering, they likely have a lot of per diem employees, which means that they're employed. We use them when we need to use them. They're gonna get a base rate. Maybe there's some form of tip that's provided. Really, my concern with using independent contractors in like a catering environment is the workers' comp aspect of it. They slip and fall, they get injured. Your liability insurance isn't going to cover that because they're an employee. They should be covered by workers' comp. But if they're an independent contractor, you don't have workers' comp for them. It becomes a parade of horribles. But in most cases, I would say they should be classified as a per diem employee who you just pay based off of when they work.
One other thing about independent contractors and workers' comp, the thing about workers' comp and employees is if I get hurt on the job, I can't sue I have the remedy of workers' comp, but I can't sue my lawyer in court in a personal injury lawsuit and really get a lot of money. I mean, workers' comp, the trade-off is, hey, we're going to give you something, it's just not going to be a lot. If you're an independent contractor, you're not covered by workers' comp, and therefore there's no bar to you suing in state or federal court. And I had a case probably 10 or so years ago where a painting company had a model where they hired people as independent contractors to basically be franchisees. And a kid fell off a ladder and was paralyzed. And their whole model, we went to them and we said, hey, if you want to defend this as him being an employee, we could probably get this kicked out. And they said, well, that's our whole business model, so we could save a couple $1 million, but it would end our business. And so he ended up suing, and he ended up getting a substantial 7-figure settlement as a result of it. So one other thing about independent contractors is, remember, you're potentially buying a personal injury suit if they're hurt on the job in a way that you wouldn't be if they were employees.
Mm-hmm. All right. So we're over time, but I want to just do a quick outro here. I want you to give me in 30 seconds, I know that's probably really hard for a lawyer to do, 30 seconds, maybe 60.
Shot at Tanya out of nowhere.
What is the number one reason you have encountered that gets a small business in water, underwater? Why are they being sued? What's the number one reason? Go.
A lack of empathy. They don't treat people the way they'd want to be treated. They kind of don't look at the larger picture, take into account that a person is a whole person. They have a life outside of work, they have a life inside of work, and they don't seek to understand kind of what's going on. So when you're dealing with people, think of empathy as kind of the top priority and then figure out where to go from there.
That's a really good one. I mean, I see
He
people.
says it like he's surprised.
I actually had a very similar interaction with my wife this morning. That's a great one. The no surprises rule. I don't know if. I've been a lawyer for 1 million years. I'm not sure if I would hate surprises as much if I did something else for a living. But I will say this. People never think that they're doing a bad job, even if objectively they are. And so, again, I gave you the example earlier where people call me up and, they fired me for doing a bad job, but I wasn't doing a bad job. How can I sue them? No surprises. If I'm telling you over and over again, hey, come on, you're not meeting my expectations, let's go, let's go, let's go. When I say, hey, I'm gonna have to let you go for not meeting my expectations, it shouldn't be a surprise. So I think having that kind of dialogue, and it's a lot easier to do it on an ongoing basis than with a formal, okay, 6 months, let's do your review. I think that's really helpful, and setting expectations accordingly so people understand what they're being asked to do.
All right. So what I heard today to summarize is that you want to go to the Department of Labor's website and learn what you don't know. Second, hire an attorney, even if it's just for an hour, to make sure that you have peace of mind. Be nice to everyone and treat them how you would want to be treated.
Be nice is always a
and
good thing to
document.
Yes,
I think that can.
And I'll say one other thing to just kind of piggyback off something you just said. A lot of times, people don't know employment lawyers because what we do is somewhat specialized. And if you haven't had a problem in the past, why would you know? If you've got a lawyer that you're working with in your business to help form your business, to help form your LLC, ask them for a referral. We get, I'm sure this happens for you a lot, and I know it does for me. We get referrals all the time from people that are, hey, I'm their corporate lawyer, or I do their real estate transactions, but I don't do employment law and nobody in my firm does. Can you help with this discrete issue? And I get, I have tons of what I refer to as co-clients with people where I'm handling their employment law stuff and XYZ firm is handling their corporate or their real estate or something like that.
Yep. All right. Well, thank you for everyone coming. Thank you for everyone online. Thank you to Gorham Savings Bank for sponsoring this series, and look for the next one in about a month. Thanks. Bye, everyone.